Okay. Thanks, Liz. Thank you, everybody, for tuning in. Today's topic, we're going to be talking about guardianships and power of attorney and healthcare proxy documents, and why you might need one, despite having the other. So for starters, just to give a little bit of an overview, what we're talking about is a scenario where an individual can no longer make decisions and take care of their own affairs. So whether that is as a result of an accident, or perhaps it's a result of age, perhaps there's a cognitive impairment, or perhaps we're talking about an adult who has developmental disabilities and is no longer a minor and cared for by their parent. How can we ensure that these individuals, this population, is cared for, that their needs are met, that their assets are handled appropriately and carefully, and that we do this with the least amount of interruption to the disabled individual's life. And so right before we started the webinar, a couple hours ago, I got an email from somebody, and it's a great way, I think, to start out the explanation. And what the email said was, do you need a guardianship if you have a power of attorney? And that's a great question, and one that comes to us often. And the answer is, it depends. So what we're talking about are the two different legal ways to ensure that there is another person who is empowered to make decisions for you if a time comes that you cannot make decisions for yourself. So in a perfect scenario, every person is going to have a power of attorney document that empowers another individual to make decisions for them, to handle business and financial matters for them, and a healthcare proxy that gives an individual the ability to make healthcare decisions. Again, in a perfect world, that power of attorney is going to be comprehensive. It's going to be accepted by all financial institutions, and it's going to give that individual the ability to really do anything that might need to be done based on any number of things that that person could need throughout the course of their life. So here we're talking about banking powers and the ability to apply for government benefits, and the ability to sell a house, the ability to transfer assets. And so for many of our clients who do their planning with some forethought, they come in and we execute advanced directives. We will execute a power of attorney, perhaps a healthcare proxy, and name individuals to handle their affairs for them. And for so many of our clients, that works well, and that is all they need. But there are instances where either those documents were not executed in time, meaning the individual comes to us and they need some assistance, maybe with an elderly parent or a spouse, and that person no longer has the requisite capacity to sign documents. Or perhaps there's a power of attorney document in place and the person who is named on the document is no longer the appropriate person to be acting. Maybe they are no longer involved in the person's life, or perhaps maybe they are not acting in the best interest of the individual. And in that circumstance, we're going to look to the guardianship court system and the guardianship statute to get another person empowered to make financial and or personal decisions on behalf of the principal. So I see there's already 2 questions. Liz, do you want to just, before I keep going?
You got it. First question, how do you decide if a special needs person needs guardianship or simply a power of attorney healthcare proxy?
Oh, great question. So that's going to be a capacity determination. And the best way for us to do that, quite honestly, is to meet with that individual. So what I'll tell you is that for healthcare proxy, the capacity needed is quite low. They need to be able to articulate who they want to make healthcare decisions for them. In order for a person to execute a power of attorney document, that capacity level is a bit higher. And so they're going to need to not only understand the document itself, but the power that they're giving the individual, and also have a good understanding of what their assets are. And that can all be done with an attorney who will make a determination of capacity And what I'll tell you is that where we can achieve that goal using documents, it is almost always preferred due to the ease, the privacy, and the far less cost involved. So.
Thank you. Next question. Is a person incapacitated due to blindness in this group?
So if the question is, does a person being blind render them incapacitated so that they do not have the capacity to execute estate planning documents? The answer is no. I would have to, if there's a particular question, I'm happy to answer it. Blindness in and of itself is not a disability that would render somebody incapable of signing estate planning documents. So there are provisions that can be made to assist in the signing of the documents. Okay, so when we talk about guardianship, in the state of New York, a guardianship is a court proceeding. I'm going to focus today on what is referred to as Article 81 guardianships. And these are the guardianships that we typically use for individuals in our practice who are adults, elderly. There's nobody appropriate to step in and assist them with handling their affairs. The window has closed, so to speak, on the ability to sign advance directives. And we need to get somebody empowered to make business and financial decisions. So the guardianship is a Supreme Court. It's a special court within the New York State Supreme Court. The proceeding is going to be brought by a petition and an order to show cause. So an individual would come into our office. We would talk about the need of guardianship. We would talk about who the right person to be guardian is. And we would submit a petition to the court and ask that the court consider this person's lack of capacity and need for a guardian. And after a review of the circumstances, that they appoint a guardian. Now, you can request that you be appointed guardian. You can request that another person, an independent individual, be appointed guardian. If you are a person and you yourself don't have somebody to name as an agent on a power of attorney, so maybe you don't have a close family member, or maybe you don't have a friend that you feel comfortable appointing and you would rather utilize the court system, you can self-petition the court and you can ask the court to appoint somebody as your guardian. And now oftentimes people say to me, well, why would anybody do that? Well, maybe you have somebody that is living in the community and they are single and they have assets and they don't want to name somebody that they don't know very well, and they would rather have court oversight. And so the guardianship courts can be used in that way as well. Most typically, though, what we're dealing with in our practice is a situation where somebody comes in with husband, with mom or dad, and they are hopeful to be able to get advance directives in place. And we find that that individual lacks the capacity to sign those documents. So we then start a conversation about guardianship. And so what we want to make sure we're doing is that we're getting enough powers in place, but not too many powers. So the statute, the way that it's written, requires that any guardianship that is brought and any guardianship that is placed is going to be the least restrictive means of getting the end result. So what does that mean? That means that they're going to give the guardian only the powers that the guardian needs, and they're only going to give guardianship to another individual if the court finds that it's appropriate and in the best interest of the principal. So sometimes I have family members come in and they say, you know, mom and I have never really gotten along that well, and I don't really get along with my sister. And my mom executed a power of attorney naming my sister, and I don't think that's fair, so I want to bring a guardianship. Well, that's not appropriate. That's not an appropriate use of the guardianship court. Now, change the facts a little bit and say, listen, my situation with my mom was never that great, and I don't really have a great relationship with my sister. my mom named my sister as guardian and her cognitive ability is somewhat diminished, and I believe that my sister is stealing money from my mom. Well, then under that circumstance, the commencement of a guardianship would be appropriate because there would be a review of what's going on with mom's assets. That being said, be careful, because if you bring a guardianship and it is found that that the bringing of the guardianship is not appropriate, you can be surcharged all the fees. And when we bring a guardianship, what ends up happening is that as the petitioner, typically you're going to hire an attorney, and the attorney is going to draft papers, and those papers are going to be submitted to the court. The court will, on its own, name another attorney who is going to be what's referred to as the court evaluator. These individuals are the eyes and ears of the court, and they're going to do a review of the finances, a review of the circumstances surrounding the guardianship, and they will make a recommendation to the court. In certain circumstances, the court will also appoint an attorney for the incapacitated person. So the person who is the subject of the guardianship is referred to in the court papers as the alleged incapacitated person, so the AIP. And the reason that they're referred to as the alleged incapacitated person is because there needs to be a finding that that individual is incapacitated in order for the court to name a guardian. So the court has to either find that the individual is incapacitated or that they are a person who is in need of a guardian, and that failure to appoint a guardian would result in that individual suffering harm. What I will tell you is that a guardianship brought because you feel that maybe your parent is making a bad decision, that's not an appropriate guardianship. We're really looking out to protect the interests of the elderly and the incapacitated and make sure that we balance that individual's rights and their right to privacy, their right to autonomy, with the importance of making sure that we've got appropriate people in place to make decisions, both for healthcare and for finances. So when you commence a guardianship proceeding, you have the ability to commence a proceeding that's going to name a guardian of the property. A guardian of the property is going to deal with bank accounts, real estate, anything financial. And you can also ask for a guardian of the person. Guardian of the person is going to deal with healthcare issues. Oftentimes you might say, you know what, we don't need a guardian of the person because we've got the Family Healthcare Decision-Making Act here in New York, and that act provides a hierarchy of persons who can make medical decisions for another individual. So we're really going to look to tailor this guardianship petition to the least restrictive alternative. The individual might have capacity to sign a healthcare proxy, but not the capacity to sign a power of attorney. And so we might, for that reason, only need to bring a guardianship proceeding to deal with the financial needs. You can have co-guardians if that's what you choose. So if you think it would be best dealt with by having two guardians to handle issues, that's certainly appropriate. You can have a guardian of the person and a guardian of the property, and you can deal with two separate people, or you can have the same person. Once the guardian is appointed, that individual, by court order, has the ability to step into your shoes and handle any of the tasks that are outlined in the guardianship paperwork. So it's important when commencing a guardianship proceeding to take a look and see what are the powers that we're asking for. Have we made sure to think about what might happen in the future? You know, maybe we're not today thinking about dealing with filing a Medicaid application, but we may want to consider that down the line. And we want to get as many powers as we can into the initial petition so that we don't have to continually go back to the court and ask for permission. Because the one difficulty with the guardianship is that it is a court proceeding and that there is court oversight. So any deviation from the order itself is going to have to be dealt with through an additional court proceeding. Sometimes it can be done with a request in paper to the court, but you're going to want to make sure that your petition for guardianship is complete and thorough. So with respect to the powers of the guardian, once the guardian paperwork has been signed, the guardian is then empowered to do things such as pay your bills, marshal your assets. Typically, a guardianship bank account will have to be opened, and that bank account is subject to review annually by the court. So as a guardian, you are required to prepare annual reports and get those submitted into the court system for review. And the reason is that they want to make sure that their court appointees are acting appropriately with respect to any financial and personal matters that the individual needs. Oftentimes, with a guardianship, people come to our office and they say, well, I think I need a guardian. And what we find is that they actually are probably okay with getting a power of attorney in place. So we're always going to want to consider a review of the individual's capacity prior to jumping to a guardianship. So you're going to want to really think about what's the best way to do this, because although the guardianship is a very helpful statute and we rely on it quite a bit, if you have the choice between a power of attorney and a guardianship, we're always going to want to execute a comprehensive power of attorney. So now the question becomes, what happens if somebody has a power of attorney, but the power of attorney is not sufficient, meaning it's a document, it's valid, it's legal, but the powers are lacking. And now that individual has lost capacity to update the document. Well, in that scenario, despite the fact that there's a power of attorney in place, we're going to have to commence a guardianship proceeding. And depending on the court and depending on the powers in the guardianship and the powers in the power of attorney, the court will either vacate the existing power of attorney in favor of a plenary full guardianship, or if you just need one temporary power to do one thing, you can always apply to the court for a limited power for a limited duration. So going back to the least restrictive alternative, you always want to take a look at that and see, are you asking for too much power? Is there a way to pare it down? Because the statute does require least restrictive alternative, which means we're going to ask for the least amount of what we reasonably need. That being said, you don't want to ask for too little. So there's always a delicate balance between the two. Once there is a guardianship in place, there's also an individual called a court examiner. And the court examiner is the person who is annually going to audit the reviews that you submit. And that person can also be a source of information for you. So if you are a guardian appointed through the courts, you can always reach out to your court examiner to try to get questions answered that you're unsure of. It's important when you are appointed as a guardian for another individual that you keep good records. You want to make sure that if you have a situation where you're wanting to take cash out of the account and give it to the incapacitated person, that you've been empowered by the court to do so. So it's very important, again, to look at the powers as they're enumerated in the petition and to work within those powers. The court system here in Suffolk County is very, very helpful on the guardianship side, and they will certainly be here to assist in anything that you might need by way of assistance on the guardianship. So that's a very helpful. The court system itself has a lot of resources that will help you deal with the guardianship and make sure that you're getting everything that you need from it. Liz, I just need to turn my screen for one quick second. I don't know if there's any questions right now.
Sure. It does not look like we have any questions at the moment. If anyone does have a question, remember on the bottom of your screen there is that Q&A. You can click on that and type in your question there.
All right, sorry about that. Working from home will get you a little bit every time, right? Okay, sorry. So with respect to just sort of a review and a wrap up, certainly one thing that we didn't talk about, the other guardianship statute is the 17A guardianship. So 17A guardianship is a guardianship that is meant to be somewhat more simple and is probably a more appropriate guardianship when we're dealing with individuals who are developmentally disabled and there's not a significant amount of assets. It is a simpler proceeding. It does not require all of the pieces and all of the players that I spoke about with respect to the Article 81 guardianship, but the ability to deal with assets is quite limited. So oftentimes when we've got an individual who is developmentally disabled and they are in receipt of Social Security and they don't have really a significant amount of money in the bank, and you just, as maybe an adult, a parent of an adult with developmental disabilities, perhaps an autism diagnosis, and that individual is not does not have the capacity to sign advance directives, we're going to look to the 17A guardianship statute, which is a guardianship that's brought through the surrogates court. There is no requirement in most cases for a hearing, and it can be done mostly on paper. And so if you have a child who is reaching adulthood, the 17A guardianship is something that you want to start thinking about probably when that child is 17 and a half, so that by the time they turn 18, you are empowered to make any sort of monetary or personal need decisions for them, because without the guardianship, you are not technically empowered to make those decisions. So that's something important to remember. And we're typically not going to utilize the Article 81 guardianship for that, simply because it's a more complicated process and probably just not necessary. Okay, so as far as a wrap up, what I would say is that where possible, we always want to rely on power of attorney, healthcare proxy, but certainly where it's not feasible, where it's not practical, or where we need another solution, the guardianship statute steps in and provides really quite a comprehensive way to make sure that the elderly and the cognitively impaired in our community who can't make decisions for themselves can be cared for safely and with some court oversight. And so it's really a great tool to use. Bye-bye.